No. It was particularly helpful actually. That's an public speaking when I just started. So when you're new, advising, depending on the size of the company you're advising, like a CEO of some company, and you have to leave the part. Yeah. And the character was so convenient and important that. We do.
This one is like light?
This one, I think you just need to turn it on.
All right.
It's not on. Yeah, I think you just need to turn it on. Oh, no, it is on.
I think they're all muted in the back.
Oh, yeah, he's probably going to turn it on when you start speaking then.
We're good? All right. Welcome, everybody. My name is François Banex. I'm the Interim Vice Provost for Innovation and the Director of Commotion. It's really a pleasure to welcome all of you today. So I was actually reflecting upon that. I've been in this position for... I need to be here on the spot. All right. I've been in this position for all of a month and a half, broadly, so it's been interesting, but I'm happy to tell you about this wonderful organization that Commotion is, its mission, and what we're trying to do. So if you don't know, and if you're not familiar with Commotion, what we're really trying to do is to help anybody on the University of Washington to achieve the maximum impact, societal and economic, based upon the research that you do. And so what that means is that, we want to talk to you about the possibility of innovating. We want to talk to you about the possibility of looking at your research results and thinking about a particular application. And we want to help you in this journey. To do so, we essentially have 4 pillars that help you through this innovation journey. The first one has to do with intellectual property advising, protection and licensing. And in fact, this is the topic of this workshop, and you'll hear much more about it as we move on. Really, the idea right here is to help you think about what you have in terms of potential. And again, I'm going to use this potential term broadly because this is both economic and societal. The second thing that we do is innovation training. And in fact, this series of lecture, the Fundamentals for Technology Commercialization, is part of this effort to basically sensitize people and to let them know about the whole process that happens, in the journey from protecting your intellectual property all the way to spinning out a company. We do offer, in addition, funding and help you forge partnerships. Funding, we have, for example, the GAP Fund, the Dub Pitch, and so on and so forth, and we'll help you connect with some of the angel and venture community. And finally, we want to help you start up your lab and do some incubation, especially in the early stages. And this building, Fluke Hall, is one example because we have actually a second floor startup that has to do with mostly wet lab type of incubation. So this is the continuum of activities that Commotion offers, and we want to make sure that you're aware of them. Specifically, as far as the Tech Commercialization series lecture set, we are actually already here. So some of you may not have seen this first lecture, but it's already streaming on our website if you'd like to visit this. But basically, the first one was to understand the path to impact. That is your innovation commercializable? Does it make sense to actually, invest into it? And what makes something really valuable in terms of societal or economic impact? What we'll be talking about today is to assess the intellectual property and protecting it. So this is all going to be about patents. This is all going to be about copyrights, and I think that we'll discuss licenses a little bit. No, maybe not. Okay, we're not discussing licenses, sorry. So mostly about patents and copyrights, and we're going to have actually, experts, Commotion staff that are going to talk about these topics. There will be 2 additional lectures in this series. They will be forthcoming. We plan to have in about 3 months or so an additional lecture that will be about building the first blocks, how you put things together towards a commercialization path, and then licensing. How do you attract interest, in your technology, or how do you form a spin-out? And that can be both positive exits, for example. You might be willing to actually license your technology to a very large company, or you may be wanting to form your own startup. So with that, I would like to introduce Fiona Wills, who is the Director of Innovation Development at Commotion, and she's in charge of essentially the whole part of the office that deals with intellectual property, copyrights, and licenses. So please join me in welcoming Fiona.
Thank you, Francois. Thank you. So I wanted to introduce the topic for today, intellectual property, and we're really trying to give you a base understanding of what intellectual property is, sort of take a step back from when you're coming to our office and trying to get it assessed. Instead, sort of understand what it is that we're talking about. So I wanted to start with the history of how universities actually have offices like Commotion that manage intellectual property. Many of you know that the lion's share of research that's done in a university is federally funded, and that funding started back, in the early part of, the early 1900s. But after World War II, it really increased a lot as the country was looking to secure its competitiveness. And at that time, the federal government was funding a lot of research, but they were keeping ownership of it. And there are some advantages to having a single entity own intellectual property in that, as many of you will have experienced, it's very rare that there's one person that invents or authors a copyright work. And so by having one entity that owns it, those rights can be aggregated. So that was a very positive part of the federal government owning the intellectual property. But unfortunately, they didn't have any infrastructure to actually be moving forward on protecting the intellectual property or licensing it. So nothing happened with it. And so what happened was in about 1980, there was the Bayh-Dole Act. You may have heard that reference before. And in that law, the universities are able to retain ownership of the intellectual property created using federal funding in their university. But in order to be able to do that, we had to build the infrastructure to be able to manage it. And so that was when you really saw universities across the country opening tech transfer offices. In addition to universities also being able to aggregate those rights, the other significant advantage of this is that if any of you have worked with us, the number one most important thing for moving intellectual property forward is having the interaction with the inventor or the author. And so by having those rights at the university, we're able to work directly with you and understand your goals and be talking about the best way to move what you've done forward. So we have been very happy with the results in terms of being able to really create much more impact. And you'll have seen that there is much more protection of the intellectual property and licensing since the universities have been able to manage it. So to introduce today's topics of what we're going to cover, as I mentioned, we want to really talk about the base of what intellectual property is and when somebody is entitled to intellectual property, an inventor or an author. Just some thoughts on when it makes sense to apply for intellectual property and when perhaps it doesn't make sense to do it. What the process is, how you seek protection, and then some critical success factors that we have found over the years, sharing them with you so you can think about them as you consider your journey with Commotion. And then next steps, because I know that everybody is going to be excited about working with us after they leave this talk. Intellectual property itself is a legal right. So intriguingly, Francois said that we weren't going to talk about licenses. In licenses, often people will very broadly define intellectual property to include data and materials. In fact, intellectual property is a legal right, and there are laws for each type of intellectual property that cover how to obtain the protection. What's important to understand is if you don't obtain the protection, then those ideas are free for everybody to use. So the premise behind intellectual property protection is the ability for you to have the legal right to manage how that intellectual property is used. What does intellectual property protect? Some people will occasionally think that it protects an idea itself. And in fact, it's the tangible documentation of an idea, or putting your idea down on paper. It's something tangible. So a work of art or an invention that has, in the form of a patent. The idea itself is not protectable as intellectual property. It is these tools that we use that bring about the protection. And then I just wanted to cover some key terms up front that we're going to be talking about today. Most of them you'll recognize as the types of intellectual property. Copyright, which is something authored, a musical work, a piece of art. Trademarks, which is how you protect your brand. A trade secret, which is something you keep secret, but there's additional laws around it in terms of the steps you have to take to truly keep it secret and benefit from that protection. And then there's the patent application, which is, we really want to make sure you understand what that looks like, what the process is of applying for a patent. So we're going to spend some time talking about what that looks like. And then, when you have a patent application, at that point, you don't actually have the full rights yet. It's once the patent issues that you have the full rights to protect your intellectual property. So we're going to walk you through all of those areas. Okay, so at this point, I wanted to introduce to you our copyright and trademark manager, Scott Smith, our colleague. So Scott did his undergraduate degree at UCLA in microbiology, and then he went on to Glasgow to do his master's degree. He went back to California to Loyola Law School, and then gradually made his way north, working with a bunch of different boutique law firms as an intellectual property attorney. Scott has a tendency to keep it a secret, not a trade secret, that he is in fact a patent attorney, because he really had his passion, his love is for the copyright and trademark part of the intellectual property practice, and that's what he helps our office with and works with researchers on. So Scott, I will turn it over to you to talk about that with us today.
Excellent. I think I'm on here. You guys hear me all right? Okay, good. Yeah, so I'm here to talk about copyright and some things to keep in mind when you're putting together projects that include copyright materials in one form or the other. So the first question is, what is copyright? And a little bit was touched on by Fiona, but it's basically legal rights and protections for original works of authorship. So it's traditionally been what's known as more artistic work. So books, music, sculptures, fine art, movies, TV, things along those lines. But copyright also protects software because it's a language, it's a written expression of an idea. The nice thing about copyright compared to patent, as you'll kind of learn later in this talk, is that protection is automatic. Once you've created it, copyright protection sets in. You may have heard about copyright registration, and that's more of an official paperwork with the federal government, and that's really only needed if you're going to sue somebody in court for infringement. But once you've created it, you get copyright protection. As long as it's original and you're not copying somebody else's work, you get the protection. There's no real hurdles beyond that. Patent, as you'll see, is a little more involved and there's a little more to prove. But copyright is a very low bar and easy to show. Copyright doesn't protect facts or ideas, it just protects the expression of those. So, for example, a recipe book, right? You have your recipe, cup of flour, 3/4 cup of milk, things like that. That's not protectable under copyright. That's just a list, that's just facts. But photographs in the recipe book, the expression, the way you describe about how combining the ingredients, if it's somewhat of an original way, just combining A, B, and C, not much there, but you talk about how your grandma did this and the importance of that and all that, that expression is protected. I think that's it on that. And then, as you'll see, patents protect more functional, utilitarian aspects of things. Copyright really doesn't protect utility of anything. So if it's something that's functional, the software does have a function, but it's not really the core of that. It's really the expression that's protected under the copyright. So why is copyright important at the university? And you may be surprised to know that slightly more than half of the revenue coming through the university for IP is copyright related. There's a ton of copyright licenses out there from the university that are for free, no fee or anything like that have great societal impact, but copyright is just as important as patent for as far as revenue coming into the university. So things to think about when you're putting together a copyright project is if you're working with UW students, what are some considerations on that front? If you're working with third-party entities, whether as a collaboration or some other form, working with them to create copyright materials. If there's some third-party materials out there that you want to use, they're already created, but hey, we would love to incorporate that into our project in some form, how to go about that. And then also, when you're planning your project, some things to keep in mind. And then finally, what we can do to help you in that process. So first, working with students. There's a number of considerations if you have students working on your project. At a base level is what kind of student are they? Are they an undergrad student? If they're a grad student, or they're one that's paying their own way, tuition-wise? Are they being funded through a grant through your lab or center or anything like that, your department? Is it through public funds, through the university, through a grant, some other type of funding? Are they using UW equipment above and beyond what a normal student would do? So an undergrad student using a computer lab isn't going to trigger anything as far as UW ownership. But if they're involved in some greater degree, then possibly UW or in your project may have that IP right. And are they being paid? Are you paying them to do this work? But the underlying thing is whatever their involvement is, you want to have some type of written agreement with them outlaying who owns what as part of your project. You don't want to get late in the game and realize that they still might have some ownership and you have to go and negotiate with them now, and that may become hurdles for you licensing out and commercializing your project. So for the external entities, some things to keep in mind is, again, and I'll be saying this over and over, is a written agreement that you have an idea of who owns what all the responsibilities of the parties are. So if it's a third party, you want to put in there who owns what rights can they use. If one party owns all of the copyright in it, can the other party use it for non-commercial uses, commercial uses, internal use only? So just kind of think about that of what's important to you as far as your project, and we can help with figuring out those details. And also other language in there might be some confidentiality requirements for third parties. You just never know. And there's a number of resources on campus that help with different phases of third-party agreements. The Office of Sponsored Programs helps with research collaborations, so they're involved at the early stage of IP ownership language. If you're going out and hiring an independent contractor outside of the university, purchasing has some great agreements that has some great language in there that will give you the necessary rights that you need. And then if you're interested in licensing out your copyright in some form, our office helps in that process. And it's always good. I mean, if you do have a question about things, you can always reach out to me or our office, and if we're not the right office for you, we'll make sure that we funnel you to the right source. Now for third-party content that already exists that you want to incorporate in some manner. Again, you need to obtain permission. Unlike in a classroom or a journal article, things like that, citation, attribution is not enough. And you really, you may have heard of fair use in the copyright standpoint, and fair use is a way to use materials legally in a way that you aren't normally allowed to without permission. But as you move from a non-commercial project to commercializing out and licensing your project for a profit, that fair use argument is tougher to make, and fair use is really just deciding in a court of law when one side or the other has been sued for infringement. And so that's proven then, and you don't really want to get to that spot if avoidable. So it's best to obtain permission, and as soon as you can, the best. And also understand the tools that you're using. So if you're using software to build your product, you want to make sure that what you plan to do with the results of that use of that software are what you want. So for example, if you're using some software like MATLAB that staff and faculty at the university can use for free, there are some restrictions on that. Your output from MATLAB is fine to use how you want, but if you do program some scripts that function in MATLAB, there may be some restrictions of whether you can release those commercially for money. So it's really important to look at terms of use of any software tools you're using to make sure that the results you can use the way you want. And then if it is an open source software that you're using, you really want to pay close attention to what the actual limitations on that open source. Not all open source software licenses are the same, and there's a wide variety of what you can and can't do. Some are very permissive and say, do what you want with it, just give us attribution, and some are really restrictive and may actually prevent you from enforcing the copyright or patent. So it's really something to take a close look at, and that's something that our office helps with reviewing and due diligence on, make sure that if you have used open source software that there aren't any issues with that. So if you're planning for any type of project, again, document. That's documenting who's involved with it, what agreements you have with them, whether that's a student or a third party. If it's third-party content, make sure you're documenting where it's from, any associated license that you have with it, and what it allows you to do. This saves you both time and money. For example, we had a project that came to our office, and it was a documentary film that came out of the University of Tacoma. It was funded by a civil rights nonprofit. Originally, the documentary was meant to just be shown in the lobby of the nonprofit's building. They hired a UW professor to create it because he had a background in the area as well. It was recreated. Both the professor and the nonprofit were so happy with the results and the feedback they got on it that they then were like, well, maybe we can, have PBS show this. Maybe Netflix may be interested to do it. Maybe we want to show it into some theaters, which is great, and we love to see that. But the problem is the early stages, they had just thought they were going to show this in-house in a particular room, and that was it. And so a lot of the permissions they got were just confined to that. It was a non-commercial educational use. It was, not shown anywhere else. And so it created all these hurdles, both from photographs used, moving images, and music. And so once it first came to our office in one form and found out of how this larger scope was coming to and where they wanted to go with it, it took 9 months to go back and clear all those rights again. And some of that included paying a fee or a higher fee. In some cases, it called completely replacing that material because they couldn't come to an agreement or the cost was so high. So the earlier you think about this stuff and thinking about it even broader than you think you may initially go with this, because you never know where a project goes, and you'd be really surprised of how they can develop over time. So just thinking about the earliest possible. And if you are using materials, is it something that would be easily replaceable or not? And if it's not something easily replaceable, you really want to have the permissions that you need. So how can we help? So if it's some copyright you want to license out, we're here for you, and that can be software, it can be multimedia, training materials. We kind of cover the board. We've been involved with documentary films, video games, all sorts of material that's gone out. So we can kind of help with that project and with that process. And generally, the creators, researchers, they manage their own scholarly work. So whether that's classroom materials, testing materials, things like that, that's something that they kind of manage on their own. But our office helps with some of this other stuff that goes out. And I'll be here after, we can talk about it. Otherwise, you can reach out to me or our office, and I'll kind of guide you through all that effort. But going back to it, just think about this stuff at the earliest stage, get everything in writing, and make sure you have that. Because even sometimes at the grant level, there's something, IP language in there that creates problems down the line and creates hurdles where you have to go back and sort of correct some of this stuff. So just keep that in mind. Now we'll dive into patents, and my colleague Patrick will come up, and he's a patent portfolio manager. He focuses on engineering innovations. He from Canada originally and spent some time at John Deere in various capacities, and went locally here at Seattle University for ending up at our office.
Thank you, Scott. Yeah, as Scott mentioned, Patrick Chinkiewski. I'm with the Patent Group, Patent Portfolio Manager with Comotion. Started about 2 years ago with the office. Before that, I was just Pat Pending. Ooh. Okay. Oh, no, nobody's physically sick. That's a good sign. I'm going to take that as encouragement. So there's 3 overarching themes to the talk today that I'd like to have you keep in mind. So number 1, you may be, or you probably are, an expert in your field of research somewhere at the university, and that's fantastic. When it comes to IP or patents, you don't have to be an expert, okay? It's totally okay to learn as you go, and after a few times through, you may very well be an expert. We have some very savvy faculty members here at the university. Second, you don't have to be an expert because we are available to you. You have any questions about the process along the way, before it gets started, in the middle of it. It's a long process, many steps, and we are available the whole time through. Third, as is the case elsewhere with your work at the university, we're sure deadlines matter with IP, and the order of events is very important when it comes to patents, and we'll get into that as we talk here today. So, threshold question, what is a patent? So you heard Fiona say we don't protect ideas themselves, but a patent is, basically you can think of it as an exchange with the federal government. In exchange for you teaching everyone about your wonderful new invention, the federal government's going to give a limited, exclusive right to your invention, okay? And we'll explain that right a little bit further on. Again, as Fiona said, it's important to distinguish that a patent is granted on a successful application. When you bring to us an idea or an innovation and we file something on it, we're not filing a patent, we're filing the patent application. There's a lot of requirements that have to be met in order to get that issued patent. So, as Scott went through some questions that we present that we get from faculty from time to time, not only faculty but other researchers. We will go through some questions here today and try to answer them for you, or at least begin to answer them. So what can be patented? Okay, not only from the standpoint of patent eligible subject matter, but also from a kind of another way of looking at it, which is what can't be patented. We'll talk about that. What rights does a patent give me? So we just alluded to that limited exclusive right that the government's going to grant. We'll talk about that a little bit more in depth. What makes a good patent? And the answer to this is kind of subjective, but in terms of what our office thinks makes a good patent, we have some qualities that we'll introduce to you. And what am I committing to? It's a long process. So we will call upon you at many stages throughout it, and it's nice to know ahead of time what that might be. How do I read a patent? This is a question we get from time to time, or at least when we're speaking with researchers, they might appreciate learning something about how a patent is laid out in some of the tricky language. How are decisions made related to patent filing? We will again briefly go through that towards the end of this presentation. But moving on to that first question, what can be patented? And so from a patent eligibility standpoint, whoever invents or discovers a new and useful process, machine, article of manufacture, or composition of matter, or an improvement thereof, may obtain a patent. Okay, but it's not like copyright. Copyright, like Scott said, there's automatic protection granted. With patents, you have to make the application. This eligibility is supposed to be very inclusive. And actually, in 1980, a Supreme Court justice, when trying to decide whether or not a genetically engineered bacteria would be patent eligible subject matter, Justice Berger wrote the meaty ruling, or impossible ruling, if that suits you better, that anything under the sun created by man or woman should be patent eligible subject matter. Okay. Now, there's always been exceptions to that, though. And if you look over here, you see that there are subject matter limitations, okay? So when it comes to biological subject matter or natural phenomena, for instance, if I have a disease or illness, my body will naturally create a biomarker. Simply measuring that biomarker is not necessarily a patentable invention under current law. There are other laws of nature that would not be considered patent eligible subject matter. So I can't go and patent the law of gravity and then sue you all for sitting in your seats here today. And then abstract ideas. So again, as Fiona said, we can't just patent an idea. There has to be some sort of concrete manifestation that we're drawing claims around. And for instance, from the late 90s to the mid 2000s, there was a lot of business methods that were the subject of patents, where people were saying, we're going to take this business idea, put it on a computer, and there's your patent. And they were granted, but a number of them were invalidated because it was decided that that shouldn't be patent eligible. So in addition, exceptions would be some other things that can't be patented, not because they're not patent eligible, but crowded fields. And like, if you think about something that's been subject to many patents, might be like a device that you'd wear on your body to improve, like a knee brace. Knee braces might be very, very densely patented, and therefore, if you even have a novel idea there, there would be some difficulty in getting it patented past what exists as prior art. And then there's also the threshold of not all patentable inventions should be patented. So you might have a great idea, but if we can't really figure out how to put it into a product or service, it becomes something that there's an expense that goes into a patent, and if we can't imagine how we're going to recoup that expense or make an impact through a product or service offering, we might not pursue that patent. You see I've got Amazon's one-click here. That's an example of a patent-eligible subject matter. Yes, it's a business method, but they anchored it very concretely in some of their business practices, and that ended up being an eligible patent that they asserted a few different times. And it's just, it actually expired 2 years ago today, so just something notable. So what are the requirements to getting a patent? So requirement one, we're going to go through 3 here today. Requirement one, a patent is only granted for new inventions. So there's a requirement for novelty. As you can imagine, novelty means that it's not been prior to the filing date of that patent application, it hasn't been publicly disclosed. And so in what ways could something be publicly disclosed that would defeat novelty? Well, if it's subject to a publication before we filed a patent application on it, if it's subject to a public thesis defense, presentation or poster session, discussion with anyone outside of a confidentiality agreement, and indeed some researchers are so cautious about that the agreement might just be breached anyway, that we would try to file something before that discussion. A public use, including prototypes or 3D printed copies. Maybe it's like a little rover that you're driving across campus. That's a public use. Or an offer for sale, which is less common at the university, but it is still, that would be considered a public disclosure. So the takeaway here, if you can, don't disclose your invention before we protect it. Meaning that if you know of an upcoming publication, come and see us first, as soon as possible, hopefully. What can a patent prevent? Well, a patent can prevent, an obvious variation of an invention can prevent you from patenting. So you might have an idea for something that, and this example here is, this is a very old patent, but somebody has invented kind of a self-articulating back scratcher, or maybe just something that you feel good about it, gives you a pat on the back. And then, so what elements of that invention might be obvious in light of an earlier existing patent, which would be for patting a baby on the bottom? So those elements would be considered, the elements of the baby patting machine would be considered prior art to the back patting machine, and you would have to have something additionally distinct, not obvious in light of that other invention, in order to get to a point where it's patentable. And then that difference is really where the strength of your patent lies, okay? So it's, these are important distinctions. Obviousness is a tricky one. Oftentimes when we include that language in an email, it's not received very well. It's a term of art, so please keep that in mind if you are dealing with us. What other requirements for patents? A patent is only granted for enabled inventions. Now, enablement is another term of art. Enablement means that if another person of ordinary skill in the art were to have your patent application and your patent application alone in their hands, would they be able to reproduce your invention without any undue experimentation? If they can, then your invention is enabled. Now, this comes up as an important requirement at the university because sometimes we'll get first materials on an invention that maybe not are completely enabling. You get like a PowerPoint presentation, but without a lot of context in terms of explanation of what's being presented or the poster itself. It's very helpful to have additional disclosure to make sure that what we'd like you to have in mind is that if we handed that material to somebody at some other university with no further context, they need to be able to recreate what you've done. That's enabled. So how to read a patent. Now, I don't want to spend a lot of time here, but there are required sections of a patent application: drawings, specs, claims. So you're going to see the same thing that occur in most patent applications. Indeed, good patent attorney practice is to have at least one drawing in the patent application that really presents the invention itself, that you could probably understand what the invention is just from that one drawing. So use the drawings if you're going to look through somebody else's patent application. A specification is basically referring to the written description of the invention. Specifically, if you're going to go and look and try and understand the invention, go to the detailed description, and it should be in the early on part where they actually are referring to the invention and its most general form there. But when it comes to claims, I guess our advice would be just don't. In terms of trying to understand somebody else's patent, the claims are probably the worst place to start. They're very uniquely written. Patent attorneys write claims that other attorneys don't write like that. Scientists, researchers, they don't write like that either. So it's a very unique area. Just proceed with caution. The best place to learn about claims is actually if you're reviewing the claims to your own invention. Then you'll start to understand. Patent abstracts may not be as helpful as abstracts for research papers. So just keep that in mind. What rights does a patent give me? Really, the only right that a patent conveys to its owner, or that the government conveys to a patent owner, is the right to exclude others from making, using, selling, or importing that invention. Okay? And that right is something that maybe a licensee could write a letter to somebody who they suspect of infringing on their patent, the patent they have rights to. But the patent owner themselves needs to convey the right to actually enforce if that infringer keeps infringing. Really, the method of enforcement is to take that infringer to court to sue them for patent infringement. So on the flip side, a patent does not give you the right to practice your invention. That seems like it should be an obvious statement, but just picture the case where you've patented an improvement on something that the underlying thing has its own patent or set of patents on. just because you've patented that improvement doesn't give you the right to infringe that underlying thing. Why patent? Well, from a business standpoint, patents kind of equal a little bit more certainty about that thing. Our group, we talked about it, a valuable patent usually tied to some sort of a business strategy, okay? And over on the right here, you'll see you got the Visis helmet. If you guys know about Visis, a local startup, they've come up with some good ideas and they've licensed some university technology, improving the performance of football helmets in terms of hopefully preventing concussions for football players. So that's a great corresponding product to a business strategy because that business strategy is marketing a very real product to a white-hot market that has money to throw at this. So there could be another reason to patent would be a need for a deterrent. So you want to stake out your section of the market, your solution to the problem, and you're putting everyone really on notice of that thing that you are going to offer as a solution. Okay? And another one would be capacity for enforcement. So it's really easy for Visis, for example, to crack open a competitor's helmet and make sure that they're not having their ideas infringed. Sometimes it's a little bit more difficult with something like a method, a patent to a method, but you'd want to do the best you can to make sure that there's a good ability to see that whether or not you're being infringed. Why not patent? It's a good question to ask right at the outset. So one reason, if you're a startup or you're considering a startup, patents are kind of expensive. They're not, prohibitively expensive, but you should know up front that it will be a certain cost in getting to the point where you've got something issued. Patents are published, so you might be putting your competition on notice of what you think gives you a competitive advantage. Patents expire after 20 years. Well, that's 20 years of protection. That could be a good thing. But if the technology in your field is changing so often, or your solution is changing often enough, that patent you got 10 years ago might not be as helpful for you now. And sometimes the business value lies in secrecy rather than a patent. So you heard a little bit about what the trade secrets are. We don't deal with them so much at the university, being a public university. But for example, a startup that we have coming out of the university is Augury Design. And they'll take a snapshot of your website and give you some instant feedback on how it's going to appeal to certain demographics. Okay, very helpful tool for website design. Now, their initial run at that included a lot of feedback from those different demographic groups and what sorts of things appeal to those demographic groups. But after iterating that system over and over again, they might start to see that the results change. And they might adjust their algorithm for doing so. And as they get more feedback from more demographic groups, they might have better predictions. So it didn't really make sense to go out and patent that if it's going to change so much, but also from the standpoint of that data that they have is probably the most valuable part of their business. So it's not worth making any part of that public. Are you considering filing for a patent? By now, I hope maybe you are. But here's what you need to know. There's going to be a little resistance. Okay. Wah, wah. Okay, so seeking protection is a long journey. We've alluded to it a couple times. Of course, the protection lasts for 20 years, but the upfront work also takes on the scale of years. It's probably very hard for you to read, and we kind of planned it that way. We'll have another slide where it lays it out a little more simply, but where you would submit your innovation to CoMotion, there's a lot of steps before we even hear back from the USPTO, the United States Patent and Trademark Office, on what they think the patentability of the invention is. And then before we get allowance, this is 2, 4, 5 years, can be. We recently had one from where we made a U.S. non-provisional application. That's the examination that will, or the application that will be examined It was almost 5 years before we heard back from the USPTO. It takes time sometimes. Does this all make sense? Here's a little bit more of a simple timeline. It's easier to follow. So you've got a public disclosure coming up. And you might, on your own, make a strategic decision to innovate. And that might look like you running into the CoMotion headquarters yelling, "Eureka!" Or it might be sitting down with one of our innovation managers and talking about whether or not we should be pursuing a patent on this. If we do, we hope that the provisional filing actually moves ahead of this public disclosure, because that's going to do a better job of protecting our ability to file foreign patent applications. And 12 months from that provisional filing, we are going to file a non-provisional application. Non-provisional application is basically the one that's going to be examined by the USPTO. Provisional application is our placeholder. We're disclosing that thing to the USPTO. We're not going to get it examined. It's not going to publish. It's the non-provisional one that's really where the rubber starts meeting the road with a patent application. In those intervening 12 months between that, we're going to assess the IP landscape. So we're going to look at maybe what other patents are out there on that technology, the market, the opportunity, those types of things, get that commercial and that IP picture. And then further on, the application will publish. There will be an examination period, and then hopefully we get to an allowance and an issuance. During this pending period, there might be even more reassessments of IP and commercial opportunity. If there's a licensee who has taken a license on this technology and they're reimbursing on patent costs, then they have an opportunity to guide patent prosecution. Okay? If they want to provide some feedback on what they would like to maybe steer towards in order to get something to allowance a little bit quicker and take a little bit narrow coverage, then that would suit us fine as the university, as long as we're not negatively impacting the value of that IP. I don't know how I'm doing for time. Okay. Deadlines and requirements that can't be missed. So I said at the beginning, deadlines are important. I think I've mentioned it a few times here, but in the last two slides, the map of all those different points along the road where things get filed, they're all subject to deadlines. And if we miss a deadline, we abandon rights in the patent application. So we really got to stay on top of our deadlines. Additionally, you might be receiving emails from our students at the office, our paralegals, occasionally from our patent portfolio managers, where we're trying to get signatures from inventors for either an assignment or declarations. Those are sometimes subject to hard deadlines as well. So it's great to hear back from you, even if it's only out of town this week. We'll get back to you. Thanks. Additionally, there's something else that I would mention here. There's an ongoing duty of disclosure for inventors and anyone involved in a patent application. If you learn of some sort of relevant prior art reference while that patent is in prosecution or being examined, it's a duty to let us know about it, and we will file that reference with the patent office. Not doing so, one of the consequences is patent invalidation. There are others. So, lastly, patents only protect what you file, which, thanks, Captain Obvious. Yeah. But what we're talking about here is that we might file a provisional kind of early on in the research stage, and that's fine. If your research continues for the next 12 months before we file that non-provisional, that's fine too. That can be incorporated in the non-provisional. But once we file that non-provisional, you can think of it as set in stone. Okay? We can't really add any new matter at that point in time. So we need to kind of get everything in at that time that we can that's relevant to what we want claims on. That's about it for me. So I'm going to pass it back to Fiona to wrap up our presentation here today. It's been a pleasure speaking with you all, people of the future, watching this on a recording. Thank you very much.
Thank you. So I just wanted to spend a few minutes at the end here to next. And I think the number one message we want people to know is that it's never too early to start working with us. And even if it's just that you have questions, we welcome the outreach and talking to us. So what are our next steps? I'm just going to hold it as if it's working. What are our next steps for working with us? We have a consultation request form. Now, truthfully, you can email anyone if you happen to have their card. You can phone up our office, but we actually do have a form that you can fill out online if you're on our website and do a consultation request, and really just anything you want to talk to us about from, I have a question about, what this market sector looks like, or does this look like something that's protectable by intellectual property protection to you, right to you're actually pretty sure of where you're going. It's just a great place to start with our office. And then the other thing to know is that this is a series, as was mentioned by Francois in the beginning. This is the second of our Fundamentals of Tech Commercialization talks. The next one is on project development. So typically when somebody discloses to our office, there's a number of resources, some time, some work that goes into getting it ready to the point where it's ready to be licensed out. And so we want to talk to you about what all of that looks like. And there's also a fourth one in the series we're planning on when you're ready to talk to industry, how to engage them, how to get them attracted to your project. So we look forward to you coming to more of this series. Then if you actually feel like you're ready for more than a consultation request, if you know that, maybe you've done one before, or maybe you just have your invention or your copyright ready to tell us about it. We also have a submit your innovation, a record of invention form online. So, that is another way. If you submit that, then you will hear from our office. You'll be assigned a technology and innovation manager, and they will start working with you on your project. So you're welcome to use that tool. And then each of you has on your chair a booklet that has a lot of links to different resources. And so we really encourage you to look through that and think about, which of those you'd like more information on and explore that. Okay, so we're at the Q&A portion of the talk. I will ask Patrick and Scott to come back up and join me and answer all the questions, and not me. So please let us know if there are any questions. Thank you.
Is it possible to ask you who's likely to object to my use of their information?
Can you repeat the question?
You're asking who's likely to object to your use of their information. Are you talking about copyright in particular?
Well, I had sent an email to an artist in the comic pages, and I said I wanted to use one strip of his comics before my class. And he wrote back and said, absolutely not.
The owner of the copyright, which may or may not be the artist, would be the ones to ask for permission, and they would also be the one to deny your permission. But I touched on it. I didn't get into it. Fair use may be able to play some role into that. So if you do have questions about that, let me know. What you can do in a classroom, you have a little bit more freedom there than if you're out as in a commercial product or an online class or something like that.
I think to that point, it's probably personality driven, what kind of a response you get to, can I use this in the classroom setting? But typically it's when somebody thinks you're starting to either cut into their business or perhaps doing something with their work that they don't like, that they're likely to object.
Yeah, this question is for Captain Obvious. How much money does it cost to patent something?
I think the rough figure we'd probably use is $25,000 by the time you're all said and done. And there's different steps that would cost more or less than a percentage of that. But let's see. At the point where you're looking to file a non-provisional patent, you're somewhere in the area of $10,000, maybe more, depending on how complex or or lengthy the application might be.
And who covers all that?
Well, that kind of depends. If we don't have and anyone else can jump in, but if we don't have a licensee signed up for patent reimbursement, but the university believes in the technology and we assess the IP landscape and commercial potential, we would pay to move that forward on a US only basis. We at times would file a PCT application to hold open foreign rights, but we wouldn't, at the university at this time, we wouldn't pursue those foreign rights on our own.
What does the patent office really look for in your application?
The invention, and that it's new and non-obvious. What does the patent office really look for in your application? That you've clearly described your invention, that enablement requirement, that what you are presenting as an invention is new and non-obvious. They do their own prior art search in addition to the prior art that we think might be relevant and we provide to them. So then it's just a matter of making sure those claims are really clearly aligned to what that invention is.
But if your invention works, but your description of your invention is incorrect, what happens then?
Yeah, that would potentially be problematic. And so he's saying, what if your invention works but the description is incorrect? Yeah, that could be potentially problematic if we don't have a way of fixing that description. If fixing the description would be considered new matter, and for this I might use the example of we get all the way through filing a non-provisional application for a sitting device, and all the research shows that we only need 3 legs on the sitting device for it to be stable. But after customer contact, we learn that, well, a 4-legged chair is more desirable. Well, we don't have that in our application, so that's the way it's been filed. It's fixed in stone.
And to what Patrick mentioned in his talk, part of the deal you make in exchange for receiving a patent is fully describing it. So it's problematic if somebody were to make an accusation afterwards that you hadn't, in fact, described your invention. So you definitely want to make sure you fully described it in the application.
This is for Scott. If you're asking for permission to use copyrighted material, what's sufficient documentation to document that you did actually get permission before using it?
It kind of depends too of what you're asking permission for. If it's something that you're a non-commercial use, something you're trying to use in class, maybe just an email from the organization, from the correct person, things like that. If you're looking for something more commercial, maybe something a little bit more detailed, and that's something that if you're interested in, I can help provide some templates and things and help through that process.
How do we balance, I don't know to whom this question is addressed, how do we balance these processes with some of the federal funding mandates to put our materials into open source contexts?
Yeah.
When do we think about what?
When you're agreeing to those grants, that funding at that stage, to see if you're fine with that. If it is, that's something they kind of thinking about at the earliest stage of what you're agreeing to. Make sure you understand that, just because you don't want to get to the point years down the line and have incorporated in this is a key part of this commercial product I want to put out, and it turns out that it needs to be released on open source. But at the same time, you can, just because you need to do it open source doesn't mean you can't build a product or service around it as well that maybe have some value. The University of Washington, the researchers have a great name. Knowing something that comes out of the university does have a lot of weight for customers. And so just because you agree to that doesn't mean something can't be built from that, but it may limit some of the things that you can do.
To build on that, when you do just make a disclosure to our office, we will ask about the funding that you received, and we will go and read those intellectual property terms. If it turns out that they're problematic, it's a bit late in the game, so we do recommend that people are aware of what they are when they're actually submitting the grant, as Scott said.
I think it's for Patrick. So say you file a provisional application and then you follow that up by, say, giving a disclosure where you speak about it in a conference or something. How does that affect or compromise your ability for an international patent on that idea or product?
So filing the U.S. provisional application should hold rights open because it's before that initial public disclosure. What we would need to do is file the PCT application within 12 months of the provisional application, which was earlier than the public disclosure, and claim priority to that provisional application. But in either case, we would probably file a PCT application within 12 months of that public disclosure in order to hold foreign filing rights open as many as possible.
So if we have an existing patent that incorporates a species that we're looking at, generally speaking, and we want to apply for a new patent that incorporates a genus of those things that we've developed, what are some hurdles that we might see?
Two of my excellent colleagues are sitting in the back row, and this sounds like a question for them. Christina or Robin, would you?
So generally speaking, a species will make a genus obvious, and therefore the genus won't be able to be patented. There could be, within that, there could be some opportunity for patenting around that. So if you had, if you knew of a new feature or category of that genus that wasn't disclosed in the species application, then that might be sort of a way of getting like a method claim to that difference. Yeah. Mm-hmm.
You can tell by the terms that were being used there that there's a bit of experience, I think.
We have time for one more question.
Okay, well, thank you very much. So we'll transition now to our networking part of the session. We're going to say goodbye to the people who've been watching the live stream. So thank you very much for joining us. And of course, thank you to everyone in the room for joining us as well. We do have questionnaires that we would love for you to fill out for us so we can understand what parts of today were useful to you and how we can build greater value into these types of talks moving forward. And there's also some super amazing giveaways that you get if you actually submit your questionnaire. So highly recommend that. There are some people in the room who are here solely for your benefit to answer questions for you, and I think that they will be wearing some visors, I believe, so keep your eyes out for visors. I don't think that anybody wears visors for any other reason these days, so you can be pretty confident that those are the people to answer your questions. And then just a request, just because it's not a very big room, if you could help us move the chairs to the side of the room, that would be fabulous. And just again, thank you so much for joining us today, and we look forward to talking to you.